you think something will be discovered or brought out that'll be significant, and if so, what?
Well, I think being here is an incredible privilege. That's my first perspective on it, and simply getting to sit with these gentlemen and be next to them as they have a conversation.
Professor Barrett, you're obviously a law scholar, and I was hoping you might sort of share with me both your thoughts about meeting Mr. Harris and the other prosecutors, and what you think is going to maybe come out of the roundtable you'll be moderating on Wednesday.
Well, I think there's no substitute for the genuine article in, historical work or law or really anything else, and that's what these guys are. And so, from my perspective, getting a chance to be with them and present during their conversation about an event that was, in their relative youth, 55 years ago, but is as timely today, perhaps more timely today than ever, is going to be extremely special. I expect that they will convey. I mean, I've spoken previously with all of them, and I've spent time with Bernie Meltzer and with Whitney Harris. They communicate an incredibly vivid experience because it's not something from the books. It's something that they lived and something that they did and something that mattered immensely and so kind of burned into their memories as they were doing it. And what they communicate is facets of Robert Jackson, who is my primary interest and project as a scholar and a writer, and the work that they did for and with Jackson at Nuremberg. Bringing law to a chaotic post-war situation where it was not so clear that an orderly, fair resolution was going to be attempted, much less achieved. And they were part of doing that. So hearing them talk about it is really going to be a privilege.
Great.
For Steve, let me ask a question. How did you get interested, John, in Robert Jackson?
I don't think you can be a lawyer or, before that, a law student without running into the words of Justice Robert Jackson and finding something there that's very powerful. He was, by all accounts, the best or one of the top few writers in the history of the Supreme Court, and his opinions convey that in a very powerful and direct, informal writing style. So it was first his words as a Supreme Court justice, and then as I began to work first as a prosecutor and then as a legal academic, I found that the paths I was interested in kept crossing the paths of this man's life, and it didn't take me long to figure out that he really was, from my view, a central figure of his time, of his century, and that his time is his project, his contribution is much bigger than the 13 years he served on the U.S. Supreme Court. It really is a story of, I think somewhat the history of this country. A farm boy, a public servant, part of the inner circle during the New Deal, the creation of modern government as we know it, part of the creation of modern constitutional law as we know it, and part of the creation of the international legal order as we know it through his work at Nuremberg. So all of that grabbed me, very powerfully.
Sure. Well, maybe you could comment a little about the significance of Nuremberg as far as law goes.
Well, Nuremberg, it's hard for us who were born after the fact to really understand this. That's one of the things that our three celebrity guests will make very powerful and apparent as they are speaking in the area and in the roundtable on Wednesday. Spring 1945, Allied victory in Europe, is an incredibly chaotic, dislocated, somewhat rudderless time here in the country. Roosevelt's dead. Truman's just 1 month in office as his successor, and somewhat unprepared because he wasn't in the loop. The loop kind of was confined to FDR's head of what was going on with the war efforts. And there's not really a continental Europe. I mean, the Nazis are vanquished, which leaves an enormous vacuum and an enormous cast of perpetrators and, millions of people in refugee dislocation. And all of that is part of what the Allies are wrestling with. One question is what to do with the losers, what to do with the perpetrators, what to do with the culpable. And one perspective on that question is to line them up and shoot them, and perhaps line up a lot of them and shoot them. And that was something that Churchill, for one, was inclined to advocate. Stalin, for another. Senior officials in the American government all thought that part of the victory was finishing the people who had been defeated.
Sure.
What Jackson and a couple of other people stood for, articulated, and then implemented was an alternative that really attempted to draw some lines and create some precedents and provide some examples for, I think, a better way. And that's really the start of the modern international legal order, which has agreed international norms of behavior, which established a precedent that aggressive war is the central criminal act. I mean, sort of all other crimes flow from one nation,
of force.
Somebody initiating war on another. Crimes against humanity and war crimes and conspiring to do all of those things.
Sure.
And that's what they prosecuted at Nuremberg, and they prosecuted it in a way that pulled together 4 very disparate legal systems, American, British, French, Russian, into a system that's now become familiar through the work at Nuremberg and through the successor tribunals, that allowed people to have real defense counsel, to get access to evidence, an opportunity to defend themselves, real due process. So it's part of the constitutional heritage that we had here that, in a sense, we've shared with the world through the development of these international legal norms. That's part of what Nuremberg is.
Now, is your primary interest then in Jackson, in Nuremberg?
Well, I'm writing a book about Jackson at Nuremberg.
Oh, okay.
So that is
together. Okay.
Right. That is the focus of one of my projects, and there's a vast Nuremberg literature, including magnificent writings by Harris, Meltzer, and King. What I'm doing is a bit more biographical and less trial focused. The Nuremberg literature, for example, Whitney Harris's book that you have here, is a majestic compilation and description of the evidence, the proof of what
the crime was.
The crime was what the prosecution demonstrated
Sort
about.
of a brief for the prosecution.
Well, it's not an advocate's book. I think, to his great credit, he some years intervened by the time he wrote this. He sort of was able to step back, and the case had been won or lost. 12 were convicted, 3 were acquitted. Subsequent trials had largely been completed, and what Whitney's doing here is making accessible to an English reading audience the evidence, which is really not contested material. The judgments that you apply to it, that may be a place where an advocate would argue, proven or not proven, or proportional or disproportional. But this is what the Third Reich did.
And what you're writing about?
I'm writing about who Robert Jackson was, what he thought, what his decision-making process was during the year where he was the architect of this international trial and then the chief American prosecutor. And although it's within the framework of 1945-46, Jackson at Nuremberg, you really can't write about 1 year out of somebody's life without studying their whole life.
Whole life, sure.
So,
Absolutely.
so I'm writing biographically about Jackson at Nuremberg, but I'm writing more generally about Jackson.
Okay. Excellent. As far as Nuremberg goes, and its significance, when you said that, it's part of the precedent, obviously, for modern or present-day war crimes trials.
Right.
Is there...
And the International Criminal Court that the world is on the brink of creating. Actually, the United States has been, not part of it and largely an opponent, but there's a treaty that's in the process of being ratified around the world. More than 40 nations have now ratified it. When the number gets up to 60, it will take effect, and it will create a permanent international criminal court, which is the successor of Nuremberg, which was a World War II specific tribunal, and the current Yugoslavia tribunal, which is obviously limited to that geographic area and that time period, and the current Rwanda tribunal. Each of those ad hoc tribunals is a step on the road to a permanent international criminal court, and that's what's about to take effect. It'll probably be 2004, 2005 when it's actually created.
Okay. A question. In having a court system before you have an executive is sort of a different than the way probably government has worked in the past. Certainly.
Well, we do have a United Nations. Somewhat underappreciated, perhaps more appreciated now. When you see how the president is building an international coalition and relying on alliances. You see the United Nations and the Secretary General winning the Nobel Peace Prize this year. In a sense, that is an executive and a legislative structure, and the International Criminal Court will be set up as an arm or under the auspices of the general UN structure. So, to that degree, maybe there's more.
And
than
in fact,
we've made use of.
Am I right in thinking that that the IMT, the International Military Tribunal, was an outgrowth of a United Nations Commission on War Crimes? Is that
Well, it is. The United Nations was not. It was, yes. The UN wasn't formally created until the summer of 1945, so they're sort of born in tandem. The IMT, created by the London Charter, and the United Nations, created by the San Francisco Agreement, are just days apart, as a matter of kind of birth sequence. But even before there was formally a United Nations, there was the United Nations, small t, small u, small n, during World War II, and it's sort of the Allies is really what it is, and a planning process for what becomes San Francisco and what becomes the UN, capital U, capital N. And in that 1943, 44, early 1945 period, there was a commission that gathered evidence of war crimes, and that gets delivered to the prosecution effort at Nuremberg. That's part of the proof and part of the pre-existing structure. It wasn't great, and by no means was it a turnkey operation where Jackson and company just kind of like
stepped in.
No,
but
it
had been working.
It had done some preliminary work.
Okay. All right. I'm just thinking.
Now, if you know to ask that question, you have been doing your homework.
Do you have any thoughts about, if I remember correctly, the head U.S. judge at Nuremberg was, in fact, then Attorney General, correct?
Well,
he had resigned as Attorney General.
He had very recently been fired by President Truman. He had been the Attorney General.
Former Attorney General.
Yeah, Francis Biddle.
Sure.
He became Attorney General actually after Jackson was appointed to the Supreme Court, Jackson having been Attorney General. So Biddle was Attorney General from June of 1941 until April or May of 1945 when Truman, fired is a strong way to put it, but Truman decided he'd prefer to have his own Attorney General. And as something of a consolation prize or a new assignment, Truman sent Biddle to be the chief American judge.
What I was leading up to was, do you think the two of them thought there was any? The role reversal is what I'm kind of leading up to.
Yeah,
for the two of them.
The Jackson-Biddle relationship is complicated. It had, up until that point, always been Jackson in the superior office and Biddle
Mhm.
in the subordinate office. Jackson is Attorney General, Biddle is Solicitor General, is particularly the period I'm focusing on. And Jackson then becomes a judge while Biddle is still a prosecutor, the
Mhm.
Attorney General
Sure.
being the top prosecutor. Then at Nuremberg, Biddle is the judge and Jackson is the
Mhm.
prosecutor. He's the
Sure.
litigant before him. And what had been a relatively good friendship and a close relationship foundered a bit at Nuremberg. I think it's complicated to untangle exactly what it was all about, but Jackson wasn't completely impressed by Biddle's performance as a judge.